Welcome to SQE1 Preparation Criminal Practice. This one is about mitigation by Nasir Hafizi, solicitor. The learning outcomes for this class are that this presentation is designed specifically for SQE1 criminal practice students to develop a thorough understanding of how sentencing works in theory and practice. Throughout these slides, I will explore pre-sentence reports, the content and when one is required, and the plea and mitigation, the content and the approach by the advocate. What is important is you watch all the classes on sentence. By the end, I hope you will have gained valuable insights into the sentencing process that will help you prepare for your SQE1 examination and your future career as a solicitor. SQE specification, which I always suggest that you read for yourself and make notes and do your SBAQs focusing on these areas, however vague they seem to be, is the sentencing role of sentencing guidelines, determining seriousness including aggravating and mitigating facts, concurrent and consecutive sentences, mitigation, which is what this class is about, types of sentences, custodial sentence, suspended sentence, community orders and Newton hearings, and I've done video classes on all of these areas. As always in our classes, we go through a series of test your knowledge questions. There's one slide which relates to true or false, so let's go through this. True or false, a pre-sentence report, PSR, must always be obtained before a custodial sentence is imposed with no exceptions. Question 2, true or false, a plea in mitigation is only delivered if the defendant pleads guilty. Question 3, true or false, voluntary intoxication may serve as a mitigating factor during sentence. Question 4, true or false, one purpose of a plea mitigation is to present the defendant's positive character traits to justify a more lenient sentence. Question 5, true or false, demonstrating genuine remorse can be supported by actions such as an early guilty plea or seek help for underlying issues. Question 6, true or false, a lack of visible injury is in an assault case is always a strong mitigating factor. Question 7, true or false, a defendant who is the primary carer for children may present this as part of a plea in mitigation. Question 8, true or false, a plea mitigation should be tailored to the sentencing options available to the court. Question 9, true or false, financial hardship is generally accepted as a valid mitigating factor in violent offences. And question 10, true or false, a PSR pre-sentence report typically includes the defendant's employment status, attitudes towards the offence and risk of offending. Let's just look at some of the concepts around mitigation. So understanding mitigation in the sentencing context. Legal foundation of mitigation is found in criminal procedure rules as a defence entitlement before sentencing. The practical importance of this is one of the most frequent and important functions of defence advocates in criminal proceedings is to carry out mitigation. The delivery method usually involves a speech by the defence advocate, but may include character witnesses or letters attesting to good character as well. So what are the objectives of mitigation? It's basically to secure the most lenient sentence. It's to persuade the court to impose the lightest reasonable penalty. They are attempting to do balancing exercise, minimize aggravating factors while emphasizing mitigating ones. And basically what we do is we humanize the defendant, present the personal circumstances that contextualizes the offense. The ultimate goal of mitigation is to achieve the most favorable outcome possible within the constraints of sentencing guidelines. This requires careful preparation, thorough understanding of the case and effective advocacy skills to present the defendant in the most sympathetic light while acknowledging the seriousness of the offence. So what is the four-part structure of mitigation? So it normally follows this general structure. The advocate begins by identifying the likely sentence and establishes the starting point that the court will consider. This frames the subsequent argument. So that's from looking at the sentencing guidelines. You look at the offence, then next address the circumstances of the offence, minimize the aggravating factors while emphasizing those mitigating factors relating to the crime itself. You look at the offender next, present the personal mitigation relating to the defendant's character, circumstances and background that may justify a more lenient approach. And at the end of the advocate, what the advocate does is then to present a suggested sentence, conclude by suggesting an appropriate sentence that is realistic but more lenient than the starting point, reflecting all the mitigating factors present. So how does the advocate identify the likely sentence? Research is required. The advocate must thoroughly research the range of sentences typically imposed for similar offences to identify the likely starting point. There's a strategic approach. Understanding the starting point is crucial as it establishes the benchmark from which the advocate will argue for a reduction. Sentencing guidelines are crucial here. Familiarity with the relevant sentencing guidelines is essential to accurately predict the court's likely approach and identify opportunities for mitigation. The first step in effective mitigation is establishing what sentence the court would likely impose without mitigating factors. This creates the foundation for all subsequent arguments and helps set realistic expectations for both advocate and the defendant. What address should the advocate make about the offence? So this is about the offence itself, where you're minimising those aggravating factors. The advocate must identify any aggravating factors that might lead to a more severe sentence, and then attempt to disassociate the defendant's case from these factors where possible. This requires careful analysis of the facts, presentation of alternative interpretations that present the defendant's actions in a more favourable light. Maybe one of the aggravating factors is there's a suggestion that he has a leading role, the defendant has a leading role, and you disassociate that perspective and say no, he had a low or a medium level role, not a leading role. And then the other thing that we do is we emphasize mitigating factors. So simultaneously the advocate should highlight any mitigating factors relating to the offence itself that might justify a more lenient approach. This might include limited involvement, absence of premeditation, minimal harm caused, unusual circumstances that partially explain without excusing the behaviour. I don't know, maybe the property's been recovered and not been damaged. Or how is age a mitigating factor? Well, when it comes to a couple of things, youth, courts generally show greater leniency towards young defendants, particularly those who are immature and impressionable. Advanced age, elderly defendants, especially those with no previous convictions. In my experience, I think a lot of defence advocates would also say this, will often receive more sympathetic treatment as offending is considered out of character. That's the opposite of somebody who's a career criminal, who's at an advanced age and is still carrying out commit the crimes. This is somebody who's a defendant who's got no previous convictions and commits an offence. Then you've got maturity level. Defendant's emotional and psychological maturity, which may not correspond with chronological age, can be relevant to sentencing decisions. So age can significantly impact sentencing decisions with both young and elderly defendants, potentially benefiting from age-related mitigation. Advocates should carefully consider how to present age-related factors in the context of the specific offence and the defendant's personal circumstances. Is health considerations effective mitigations? It can be. Long-term illness or injury may elicit sympathy from the court and potentially influence the type of sentence imposed, particularly if incarceration would be especially difficult. Mental health, mental illness such as depression at the time of the offence may be considered mitigating, though advocates must present professional evidence to support such claims, so there should be some sort of doctors or medical evidence to support that. Addiction issues, while intoxication is generally an aggravating, is aggravating, evidence of addiction may support arguments for rehabilitation post-sentencing rather than custody. So even though it's not an aggravating, even though it's an aggravating factor, if a person is addicted, you're focusing on some kind of sentence that has a rehabilitation, community-based penalty. I know, attending a drug awareness course or alcohol treatment order type sentence, but not prison. Health-related mitigation requires careful handling. While courts may be sympathetic to genuine health concerns, advocates must avoid suggesting that substance use excuses criminal behaviour, as this typically backfires. Instead, focus on treatment opportunities and rehabilitation potentials. What reduction in sentence may a guilty defendant receive for cooperation? Well, maximum reduction, potential sentence reduction for an early guilty plea at the first available opportunity. 10% reduction, last minute change of plea at the door of the court. And in some cases where a defendant gives full cooperation with the police to find a weapon or to identify other suspects or to give evidence against suspects, it could be 100%. Courts give significant credit for early guilty pleas, with the amount depending on when the plea was entered. Advocates should emphasise not only the plea itself, but also any additional cooperation, such as naming accomplices, revealing stolen property locations, or making prompt confessions that save police investigation time. What is meant by demonstrating genuine remorse? It's more than mere apology. A simple apology delivered by the advocate simply has limited impact. Courts look at evidence of genuine remorse through actions, e.g. a letter sent to the victim to say "I am sorry," written by the hand of the defendant. Voluntary compensation, making good any damage caused, or voluntary compensating the victims, demonstrating taking responsibility, especially if the defendant has limited means. Paying for a damaged window, for instance, prior to the court hearing. Addressing root causes, taking steps to tackle problems that led to offending, such as voluntary seeking treatment for addiction, showing commitment to change, or even before the court imposes any sentence, the defendant has taken steps to address those issues. Future prevention, evidence of lifestyle changes or support systems put in place to prevent re-offending demonstrates forward-thinking responsibility. Somebody, say for example, has been involved in dangerous driving, involving a high-powered vehicle. Maybe they've sold that vehicle and bought a low-powered, a cheaper model type vehicle. What character considerations are made in sentencing? Well, this is important. For some, previous convictions, recent or similar previous convictions typically aggravate sentencing. Advocates should distinguish current offences from previous ones where possible and explain the circumstances of prior offending. Good character is a big issue. Absence of previous convictions is important mitigation that may make custody inappropriate, even if custody threshold has been crossed. Look at the cases of R. Steed and R. versus Stark. Character evidence, I've done this many times, calling character witnesses or presenting character letters, hundreds of them, can strengthen the claims of good character, particularly for defendants with no previous convictions. And, positive good character letters and witnesses do help. Are family circumstances good mitigation? Well, family circumstances can significantly impact sentencing decisions. Stable home, employment situation with supportive family members suggest a lower risk of reoffending, so that's the reason why we put it like that. Conversely, troubled backgrounds such as broken homes or childhood abuse may explain, though not excuse, criminal behaviour, particularly for younger defendants. Pre-sentence report typically address family circumstances in detail. Advocates should reference these findings while emphasising either the stability that will help prevent reoffending or the genuine attempts to overcome difficult backgrounds. How should the advocate address reoffending risk? Well, it's in the pre-sentence report. Probation service make an assessment of reoffending risk. There's the risk factors, identification of circumstances that increase or decrease risk. Protective measures, support systems and changes that reduce likelihood of reoffending. So the risk of reoffending is crucial consideration in sentencing decisions. Advocates should highlight any low risk of assessment in the pre-sentence report and emphasise factors that suggest the offending was a one-off aberration. Evidence of remorse, lifestyle changes, support systems all contribute to arguments that the defendant presents minimal risk to society in the future. Should the advocate suggest an appropriate sentence? Well, yeah, basically, thoroughly understand the sentencing guidelines and precedents for similar cases. Be realistic. Suggest a sentence at the lower end of the possible range, but be realistic. Alignment. Emphasize if your suggested sentence matches the pre-sentence report recommendations. The pre-sentence report often does make a recommendation, and your suggestion aligns with that. So justification, connect your suggestion to the specific mitigating factors present. The plea mitigation should conclude with a specific sentence recommendation that reflects all the mitigating factors presented. The suggestion must be realistic while still advocating for leniency. When the advocate's recommendation aligns with the pre-sentence report, this agreement should be highlighted as it strengthens the argument for that particular sentence. What is a pre-sentence report and when is one ordered by the court? So just to go back on this, a pre-sentence report, PSR, is a document prepared by the probation service to assist the court in determining the most suitable sentence for an offender. It provides information about the offender's background, circumstances, risk factors and rehabilitation prospects. The content of the PSR typically includes the offender's personal history, previous mitigation, family circumstances, employment status, physical and mental health, substance misuse issues, attitudes towards the offence, risk of reoffending, risk of harm to the public, and suitability for various sentencing options. And when is it required? You look at the code, requires the court to obtain a PSR before imposing a custodial or community sentence, unless the court consider it unnecessary. PSRs are typically ordered when the court is considering a community order, suspended sentence, or where complex mitigating factors are need assessment. You know, maybe it's a young person, a young single parent or carer, a person who the court may not be familiar with. They may need to have an understanding of the individual defendant's background before sentencing. Courts commonly order PSRs when dealing with young offenders, first-time offenders facing custody, offenders with mental health or substance abuse issues, or where specific requirements such as mental health treatment are being considered. Now, reports can be fast delivery, which basically means they're delivered on the same day. The probation service is quite quick, and they prepare a written report, or they may even prepare an oral presentation on the day, or a standard delivery prepared for over several weeks with more detailed assessment. So the question here is, what is a plea mitigation? Well, basically, it's where the advocate presents the factors that may justify a more lenient sentence. The timing is delivered after conviction, but before the sentence is passed. The content that the advocate, it's the personal circumstances, the remorse, the rehabilitation prospects, impact on potential sentences, and the approach, we've said it before, realistic, factually accurate, focused on relevant factors. It's basically where the defence advocate shines and speaks on behalf of, makes submissions on behalf of the defendant, who's either pleaded guilty or been found guilty after trial. Its aim is to present the defendant in the most favourable light, if that's possible, and provide the court with reasons to impose a more lenient sentence. While acknowledging the seriousness of the offence, effective pleas in mitigation highlight genuine remorse, positive character traits, efforts at rehabilitation, and personal circumstances that contextualise but do not excuse the offending behaviour. The plea should be tailored to the specific sentencing options available to the court by taking into account the sentencing guidelines, which we've already looked at. So, just as an example, 8 points of good mitigation for Section 47 ABH case, and then we're going to look at bad mitigation in an ABH case. So where there's genuine remorse, where maybe self-defense went too far, maybe there's mental health issues, maybe the person's got good character, maybe the person was provoked. Family responsibilities, to take that into account. Rehabilitation prospects and medical conditions. All of these are good mitigating factors in ABH assault case, but they should be supported where possible with evidence, and a lot of the time that's what I do. And then 8 points which would not amount to good mitigation in a Section 47 ABH case. Voluntary intoxication, that's not a good that's an aggravating factor, not a mitigating factor. Blaming the victim, lack of visible injury, that's not good mitigation. Personal hardship from conviction, vague claims of remorse, financial difficulties, they rarely work. Claims that it was just one punch. I mean, it just sounds like you're trying to minimise culpability. And character witnesses who have never seen the defendant recently. They're all bad ways of doing mitigation. We go back to the true or false questions. Feel free to pause the slide, look at the answers, check you got it right. And watch the video again as well, just to get a good idea of what's being said here about mitigation and plea mitigation. Final slide, as always, watch all the videos in the SQE Prep Criminal Practice series. Understand the functional legal knowledge yourself by checking the SRA website. Be up to date with it. Revise from a really good SQE book. Attend, participate in class. Prepare those Q&A flashcards if it works for you. Practice as many SBAQ as possible once you've got an understanding of those functioning legal knowledge. Subscribe to the channel, Community Legal Education. Put your notification on so you don't miss out. I hope you found this useful, this class. See you in the next class. And as always, thanks for watching.